when making opening arguments in a medical malpractice case, is it better for an attorney to use an outline or a script or something else to use as a reminder of what it is that he needs to talk about? Would you like to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you will find that the best trial attorneys in New York do not use a script. You will find that the best trial attorneys in New York don't even use an outline. Some of the best trial attorneys in New York don't use any notes to refresh their memory about what it is that they need to talk about during opening arguments. Now, why is that? It's because as your case gets ready for trial, as your case approaches trial, the attorney is going to spend a tremendous amount of time practicing opening arguments. They're going to go through over and over and over again, practicing in their own mind the various arguments that they're going to make, the various presentations. And when you actually go in and observe the attorney make their opening arguments, those types of lawyers tend to be the most interesting to watch. Why? Because they make it seem effortless. They make it seem so simple and easy. They make it seem as if they're just having a regular conversation with a group of people sitting in a courtroom. Those are the best attorneys. Now, why does that happen? It happens because these attorneys are extremely experienced. They know that a jury is not going to appreciate them standing in front of them, holding a script, reading word for word, like you see in these news episodes, where now somebody's standing there reading, "Ladies and gentlemen, my name is Gerry Oginski, and my client's name is Mrs. Jones. We are here to..." Because it's formal, it's stilted, it doesn't sound right. You see, when we're standing in front of the jury during opening arguments, our goal really is to have a conversation with the jury, to get them to understand what our claims are, to get them to understand what the story involved, why we believe that we are more likely right than wrong, that what we are claiming is true, that the doctor was careless, and that his carelessness caused you significant harm and injury. And if we can't connect with the jury, now we've got a problem. The other issue with attorneys using notes, using outlines, using a script, is that they don't have eye contact with the jury. Now, here's a problem. Okay, right now I'm shooting video. I'm in the hot sun, the Caribbean sun, and I'm wearing my eyeglasses, my sunglasses, they're prescription. I would love to go ahead and go like this and shoot my entire video like this. Why? So that you can see my eyes, so that I can see you as you're watching this video. That is the ideal situation. Because when you're talking to somebody face to face, how comfortable does it make you seem when I'm standing there with my sunglasses on and you can't see my eyes? That's a problem. It's a big problem. Because now, once I take my sunglasses off, now you can actually see my eyes. You can see my reaction. You can see my emotion. You can see everything that happens. And that's critically important. And I would love to keep my glasses off and switch into my regular eyeglasses. But the problem is the sun is so strong here. And now, even though I have a little cloud cover, it's still very sunny. And I can't walk out here without some type of sun protection. So, when you're standing in front of a jury, it is critically important to maintain eye contact with the jury. And if a lawyer cannot do that, if he cannot maintain eye contact and is constantly looking down at his notes, that's a problem. And it's a psychological problem, and it's an important one. Let me give you another example. Let's say you're talking to somebody. Let's say you go into an attorney's office, and now you are looking at them for the answers to your legal questions. And the attorney, instead of looking you straight in the eye, now instead stares off at a 45-degree angle at the wall over there and talks to the wall, even though you're standing right here in front of him. "Hey, Mrs. Jones, let me tell you the answer to your question." Instead of turning to you and saying, "Mrs. Jones, let me tell you the answer to the question. I know the answer and here's why." So let's get back to the title of this video. Do the best trial attorneys in New York use notes? Sure they do. Do they use outlines? Yes. Do they use scripts? Absolutely not. You don't want to divert your eyes from the jury if possible. And if you're going to do that and you need something to refresh your memory about what it is you need to talk about, fine, stop for a moment, go back, refer to your notes, then pick your head up and start talking to the jury again. That's what I find the best trial attorneys able to do. So why do I share this quick information with you? I share it with you just to give you a little insight and understanding into what happens in these medical malpractice cases in New York. You know, I do recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.